This week we will be talking about the False Claim Act. Here are some of our objectives. The False Claim Act is one of the government's most powerful tools for fighting fraud and abuse. It was enacted during the Civil War. And during the Civil War, the federal government used a large number of private contractors whom took advantage of the situation. For example, selling inferior goods such as sand instead of sugar, sawdust for gunpowder, and boots made of cardboard. So President Lincoln declared this to be a false claim to the government, and that is why sometimes it is referred to as Lincoln's Law. The False Claim Act prohibits the knowing submission of false claims for payment. It prohibits knowing the use of false records or statements to support those claims, knowing an improper retention of money owed or belonging to the federal government, as well as conspiring with others to commit any of those acts. A false claim may be seeking reimbursement for services that are not medically necessary, services not actually provided, filing a claim for services not covered by Medicare or Medicaid, filing a claim for services or treatments delivered to a patient who does not exist, or even filing a claim for services to a patient who is not a qualified beneficiary. Making false records or statements in support of a false claim. This prohibition can occur only when a false claim has been submitted. False claims are almost always supported by some form of documentation. The medical record may be altered, more so in the day in which we had paper records. False certification of patients' qualification for Medicare may be created. The basis for False Claim Act liability is often referred to as a reverse false claim. So rather than filing a false claim, the person or the organization hides or avoids paying money that is owed to the government. And the government says you have 60 days from the time that you discover you have received an overpayment to return the money. Any person who knowingly conspires to commit a violation of the False Claim Act under this section of the False Claim Act, there must be at least one other person involved. The conspirators must agree with each other in doing something that would be a violation. The False Claim Act covers healthcare providers such as physician practices, hospitals, pharmacies, drug companies, laboratories, and ambulance services. Technical violations do not create a false claim. Mistakes do happen. Healthcare providers will not be held liable for reasonable interpretation or relevant laws, regulations, and contracts. The term knowingly attempts to define the necessary state of mind of the person submitting the claim. The person must have actual knowledge that the claim is false. The person must act in deliberate ignorance or reckless disregard, and it is not necessary to prove specific intent to defraud. The term qui tam is Latin for whistleblower. Actually, I apologize. The term qui tam is Latin for who as well, and a qui tam person is also referred to as a whistleblower, or also a relator. A private citizen may bring a False Claim Act lawsuit on behalf of the government, and such citizens are referred to as whistleblowers or a relator. The government may then take over prosecution of the case. The whistleblower is awarded anywhere from 15 to 25% of damages awarded in the case, in addition to recoupment of attorney's fees. The consequences for violating the False Claim Act are several and serious. The damages are the difference between what the government paid and what would have been paid without the violation. The person or organization could be temporarily or permanently excluded from participating in government programs such as Medicare and Medicaid. So in addition, the amount of the actual damage can be tripled. So take as an example 1,000 improper upcoded claims with an average gain of $50. 1,000 times 50 times triple damage is $150,000. The court, though, may also assess a penalty of a minimum of $5,500 to $11,000 for each claim. So in the end, the organization or the physician will pay back $5,500,000 in penalties. The False Claim Act is a civil statute with a lower standard of proof, and there are federal criminal laws that cover many of the same activities but require a higher standard of proof. Some actions for which criminal prosecution and conviction is possible include knowingly or willingly making a false statement or representation, making a false statement relating to a false statement relating to qualifications for participation, knowingly committing healthcare fraud, and obstruction of a criminal investigator. Some risk areas for providers including billing for services not delivered, filing a claim for services or treatments for patients who did not exist, violating the anti-kickback law, which is receiving money or property in exchange for referrals of patients. Seeking reimbursement for services not necessary is a violation, and under the federal stock law, physicians are prohibited from referring patients to or ordering goods or services from entities with which they have a financial investment. Other risk areas include falsifying hospital cost reports, redlining, and that means hospitals and insurance companies can increase their profits by enrolling only the most healthy of patients. Illegal kickbacks, inflating drug prices, the Medicaid best price fraud, as well as pharmaceutical benefits manager fraud. The majority of cases originate with qui tam relators and the law firms representing them. In fact, in 2007, $2 billion were recovered in false claims, and over $1.5 billion was in healthcare fraud. So listed here are ways to minimize exposures to the False Claim Act. I would encourage you to review the compliance plan for hospitals, which is provided under the web link tab. But the bottom line is, even with an effective compliance program, one can never eliminate all fraud. Please do not hesitate to give me a call or email me if you have any questions. Thank you.